Well, the Koforidua High Court, presided over by His Lordship George Koforidua, has this morning granted bail to former chairman of MPP Freddi Blay to the sum of 800,000 Ghana cedis with two sureties who should be residents of either Greater Accra or Eastern Region. The lead counsel for Freddi Blay, Godfred, the former Minister of Justice and Attorney General, told the court that Freddi Blay is sick. Therefore, his continuous detention will be detrimental to his health. He also said his client was unaware of the bench warrant issued by the Akropong Circuit Court. He added that Freddi Blay is a lawyer of 48 years practice and in good standing, and served in various capacities as First Deputy Speaker of Parliament, former chairman of the leading MPP party, served in various positions in the executive arm of government, whose place of abode is known to many people. Therefore, he will submit himself to due process. As a result, must be granted bail. The application for bail was not opposed by the prosecution. However, he urged the court to ensure that any decision taken would commit Freddi Blay to avail himself to the court process. Delivering his ruling, the judge upheld the view that Freddi Blay is aged with deteriorating health and also not a flight risk, therefore granted him bail, which was varied from 800,000 with two surety both should be public servants to 800,000 with two sureties to be residents in Greater Accra or Eastern Regions. Godfred spoke to the media expressing disappointment in decision of the Akropong judge.
I think the first comment I make is that ordinarily this would not have been difficult at all. So clearly the denial of bail to Freddi Blay was quite unusual because almost every offence in Ghana is bailable. Apart from that, you have regard to the person's circumstances, his means in the jurisdiction and all that. Somebody with very sufficient ties in the country, no one can reasonably expect that Freddi Blay is one person who absconded from the jurisdiction, let alone evade the process of the law. And for that matter, clearly, bail should have been granted. It's an offence that is quite spurious, without any basis at all. He never committed the offence that he's been charged with, which is causing unlawful damage to property. And in the prosecution's case, or the facts of the prosecution's case, it's a show that he was not the one who authorized the alleged destruction of any property. And indeed, there was no property at all on the land, or there was no building on the land to be destroyed. There was no building at all. So, I mean, these matters that are quite strange. I mean, I see this development as very unhealthy for our judicial system. It brings the judiciary to dispute when they have such a person denied bail and be sent on remand for about 3 weeks to come back after the Easter holidays. They can only be to punish a person unjustifiably. Unjustifiably because the matter has not even been gone to. And if you go into the matter, you see that clearly he cannot be guilty of the offence at all. It's something that eventually, yes, he will prove in court. And thankfully, the presiding judge also varied the condition. Was for him to have been put through the requirement of having two public servants and all itself will be a little bit not necessarily hard, but a little bit harsh. And I thought that it ought to be varied, and it was varied in the way that it was done. But I'll say that, I mean, we very much deplore the conduct of the Civil Court judge at Koforidua. We think that such conduct, apart from bringing the judiciary into disrepute, is actually symptomatic of some judicial high-handedness. High-handedness in the sense that he was treated from our perspective, perhaps on account of his background, political background and all that. But this is not a matter that bail be granted to any person at all, no matter how high standing or low standing the person in society. And so how would you treat him in this way, especially when there's even no evidence of service to the summons and whatever?
How he said Freddi Blay is on admission but recovering. Eastern Regional Secretary of NPP, Tony Koforidua spoke to the media after the court case.
He has not even been served, and even per the laws of the country, you cannot even give somebody 3 weeks remand. Looking at the case, so justice has been served, and I think it's a good for the country.
Supporters of the NPP in New Drabin South massed up at the premises of the Koforidua High Court.
asase issue bi ho yɛnso sɛ deɛ yɛdɔ no na yɛte yɛ no na yɛsɛ yɛbɔ di n'akyi ɛbɛtae n'akyi nti yɛba ha nom a na yɛ fɔma chairman nti na yɛwɔ ha nom nti yɛsrɛ sɛ ɔmo mfiri.
The Akropong Circuit Court in the Eastern Region on Monday, March 16th, 2026, remanded Mr. Freddi Blay, the former national chairman of NPP, based on an arrest warrant issued a year ago over a disputed property demolition at Aburi Ketase. The enforcement of the arrest warrant led to the arrest of Mr. Blay, a veteran legal practitioner and political figure in Accra, and was quickly arraigned before the Akropong Circuit Court. He was expected to remain in custody until 9th April 2026, but fell ill as a result of high blood pressure and was sent to the hospital. Reporting for GH1 TV and Star FM, Koforidua, Eastern Region.